Hello, and welcome to FFRF's Ask an Atheist. I'm Rebecca Markert, the legal director here at the Freedom from Religion Foundation, coming to you live from the Stephen Ewell Friendly Atheist Studio in Freethought Hall, the national office of the Freedom from Religion Foundation based in Madison, Wisconsin. Today we're going to talk about a persistent topic in the United States, the placing of 10 Commandment monuments in public spaces. As always, we want your questions on Ask an Atheist. You can put them in the Facebook comments below or send us an email at askanatheist@ffrf.org. Today, I am joined by Sam Grover, one of our very own attorneys here at FFRF. And just last week, he traveled to Little Rock to argue our 10 Commandments case that we have filed there a number of years ago. So welcome, Sam.
Hi, thanks for having me.
So before we dig into your trip to Little Rock and the argument there, why don't you give us a little background on 10 Commandments and why they're placed in public property in the United States?
Yeah, so why they're placed is a different question, but we'll start with the history of these monuments. So it's a well-documented history that we briefed the court in this case, and also the Supreme Court has written about this history in a prior case challenging one of these monuments in Texas. So the design dates back to the mid-1940s when a Minnesota juvenile court judge approached a local chapter of the Fraternal Order of Eagles with the idea of distributing paper copies of the commandments to be posted in courthouses nationwide. But the actual stone monuments were put up later in the mid-1950s when Cecil B. DeMille heard of this judge's plan. At the time, he was filming the movie The Ten Commandments, and so he teamed up with the Eagles to get the stone monuments placed around the country in order to promote the film. He ended up placing just over 100 of them. So here's a picture of the Ten Commandments star Yul Brynner at the dedication of the monument installed at the Milwaukee City Hall. Now, thankfully, through the efforts of FFRF, that monument was removed in 2002, along with several others in Wisconsin. Most were relocated to private land, which is a fine place for these religious monuments to reside.
So we've gotten a lot of those monuments removed around the country just by letters, but oftentimes we are not able to remove them through demand letters, and we do have to go to court. And of course, there are two really significant Supreme Court cases, well, three actually, one with Stone versus Graham with the 10 Commandments in a public school, but the other two on public property. And of those three, two were effectively removed after those cases. But why don't you tell us the history of the Arkansas monument that we filed a case over in, 2018?
Yeah, right. So the history of the Arkansas monument is different than this 1950s history with Cecil B. DeMille. So the Arkansas monument dates back only to 2015 when the General Assembly passed this Act 1231, which was sponsored by then Senator Jason Rapert. And for those who are not familiar with Jason, here's a little video clip of his wit and wisdom.
It's really an upside-down world, and I believe that God alone is the one that's able. And so as we enter that presidential election season, Representative Bentley, my hope is that the people of this nation will re-elect Jesus to be on the throne here again in our country. Because when the country started during the Revolution, one of their phrases is, "There is no king but King Jesus." And they knew that he was really the one that needed to be worshiped and needed to be responded to.
So we kind of know where he's coming from here. That was the sponsor of the
Rapert.
bill.
That's who he is.
We do have a clip from a local news source that summarizes the court case, so why don't we play that for the audience?
We heard from attorneys representing offended Arkansans as well as the Satanic temple. They argued attorneys from the state of Arkansas, each one of them asking the judge to make a summary judgment, which would be in place of and before any trial, to hear whether or not this Ten Commandments monument that's been at the state capitol grounds the past 5 years will stay or be removed. First, I'm going to tell you about the state's argument. They said that there are 100 other monuments on public land identical to Arkansas's Ten Commandments, and that legal precedent makes them constitutional. Their key example is a Ten Commandments monument in Texas that was built in the 1950s and deemed legal in 2005 by the U.S. Supreme Court. In a 5-4 split, justices argued the monument acknowledged a historically significant influencer on our country's laws. The state attorneys also pointed to "In God We Trust" being left on money after legal challenges. But the parties against the monument had their own examples, saying the Supreme Court has heard cases surrounding the Ten Commandments on public grounds 3 times, and the Ten Commandments were ordered removed twice. Because Arkansas passed a resolution called the Ten Commandments Monument Display Act in 2015, the plaintiffs argue the state is also favoring one religion over others.
Our country is founded on a godless constitution and the Bill of Rights that follows. Our country is founded on the idea of religious pluralism, that the strength of our nation is that the government does not tell people what to believe and how to believe.
Yeah, some solid wisdom from that attorney there at the end.
Right. I think that argument should win the day. But why don't you tell us why did FFRF get involved in this case?
Yeah, so as with most of our cases, it starts with local people reaching out to FFRF about things happening in this case, their state. So we represent at this point 4 local citizens who take issue with the Ten Commandments. We have Ann Orsi as our lead plaintiff. She identifies as an atheist and is a member of FFRF. And then we have 3 other plaintiffs. We have a Jewish rabbi, we have a Wiccan, and we have a Christian. And they all take issue with this idea that the state of Arkansas is telling them what to believe and how to believe. We also represent some organizations in the case. And maybe you heard in the video clip there that we're not alone in challenging the Ten Commandments monument.
I was just going to ask about that.
Yeah, so there's 2 other plaintiff groups also in the case. The ACLU represents a few local individuals as well. And then intervening in the case is the Satanic Temple, who after the Arkansas Ten Commandments monument went up in the state, they requested that their statue of Baphomet go up as well. So they intervened in the case, and they have some slightly different legal arguments about equal protection. But it all stems from this same idea that the state is trying to push Christianity specifically on its citizens.
So you went down to Arkansas to argue at the district court level. And I'm just like going back to my days before law school and imagining what an oral argument would look like. And I want you to kind of describe that for our listeners or our viewers, because I always just think of, like A Few Good Men when they're like, you can't handle the truth, or something like, this whole court's out of order. Is that what it's really like?
It was exactly like that. I crushed it. I just went in there. I pointed my finger strongly at witnesses and at the Ten Commandments monument itself. You can't be on government property. Yeah, that's how it went.
Yeah.
No, it wasn't like that at all. There were a lot of parties here. So the state had its attorneys, and then the ACLU and FFRF, we had ours. The Satanic Temple was remote, and then we had a bunch of people listening into the oral argument because they were, parties to the case. So Jason Rapert was represented.
Was he there?
He was remote listening in, but our plaintiff, Ann Orsi, actually showed up.
Yeah, we had a picture of her that we showed just a few moments ago.
Yeah. The way it actually worked out is we all got a chance to represent our arguments to the court. We took turns. So we argued, then the ACLU argued, then the Satanic Temple argued, and all three of these groups received time to just make their argument for why the Ten Commandments monument is pushing religion on citizens. Then the state got a chance to respond, and the judge was very skeptical of the state's arguments. I don't know if we want to go into what those arguments were.
We do.
Yeah.
But first, tell me about the judge. Who is the judge in this case?
Oh, wow. You're really putting me on the spot.
You should be used to this by now, Sam.
Yeah. Baker, I want to say. I don't know anything about the judge other than her disposition in this particular case, where she was very matter of fact. She did not want any of the parties to be feeding her bullshit. She actually had to ask the state at a couple times to just be straight with her, to be candid to the court, which is an ethical obligation for all attorneys to be candid to the tribunal.
That's got to be embarrassing for an attorney to have a judge say, like, be truthful to me.
Yeah, it was not a good look for the state's attorney. Because basically, the state went in there and before even getting to the merits of what this Ten Commandments monument does and why it was put up, the state wanted the whole case thrown out on the idea that the plaintiffs in this case lack standing, this legal concept.
I was just going to say, can you explain standing?
Yeah. So the idea is that courts don't resolve hypothetical matters. They only resolve real issues between parties that have an interest in resolving a case. And it's a nice idea in the abstract, but what standing has done in practice is restricted access to courts for aggrieved parties when the courts just decide that their issues are inconvenient. So it happens a lot in state-church separation cases where a religious minority or the non-religious want to challenge what the religious majority is doing, the Christian majority is doing. And when courts don't want to decide those cases, they throw them out on standing. It also happens a lot in environmental law cases.
So it's really just shutting the courthouse door on these plaintiffs and not giving them their day in court.
Yes.
But here at FFRF, we always, unfortunately, have joked recently that a lot of the times, if these plaintiffs are Christian, they do get into the courthouse door. And what you said here, where the court doesn't take hypothetical cases, there are some cases that we've been complaining about recently that they have taken, like the 303 versus Alinas case that was just decided by the Supreme Court at the end of June, where that entire case was a hypothetical and manufactured. And the court chose to hear that case anyway. So there's really seems to be different standards for the types of litigants that are before the court.
Yeah, absolutely. The Supreme Court will pick and choose what cases it wants to hear and what it wants to throw out on standing, and it really is a double standard. So it's a problematic standard to begin with. Fortunately, in this case, there's well-established precedent, both from the Supreme Court and the Eighth Circuit, which reviews cases from federal courts in Arkansas, that we do have standing, right? So we have these 4 plaintiffs in the case who regularly go to the Capitol where the Ten Commandments monument is located. And they go there for other reasons, right? They don't go there just to see the monument, right? They've always gone there. Rabbi Levy, one of our plaintiffs, has been there 25 or 30 times prior to the monument going up. And now that the monument's there, they encounter it, right? So they're there regularly, and because the monument's there now, they are faced with a choice of either confronting this monument that tells them what to believe and how to believe and violates their personal convictions, or to change their behavior in order to avoid the monument. And that is a choice that the Supreme Court has said is untenable.
So the state is arguing that they do not have standing.
Yeah, the state is pushing this novel theory that this type of standing no longer exists. And they're doing this because the Supreme Court recently decided this case, Kennedy v. Bremerton, the Coach Kennedy case, about prayer at the 50-yard line of a football field after public school football games. And that case has nothing to do with this case, except that in that case, the Supreme Court overturned this long line of precedent stemming from this case, Lemon v. Kurtzman. Without going into it too much, basically, the state's argument in our case is that because the Supreme Court overturned Lemon, it also overturned this idea of standing based on being an observer of a violation of the Establishment Clause. Observing the Ten Commandments monument and having a problem with it is no longer a form of standing in the state's mind. The problem with that argument is that Lemon v. Kurtzman wasn't even a case that relied on what they call offended observer standing. Direct unwelcome contact was not the premise of the Lemon v. Kurtzman case. It was a taxpayer standing case. Yeah. And there's no grounds for overturning this type of standing based on what the Supreme Court has done. So the judge, when the state came up and made this standing argument, said, "Counsel, tell it to me straight. You're asking me to change the law, right? You're asking me to overturn binding precedent," which is not something that district court judges do.
Right. So it didn't sound like she was buying this argument at all.
No. And then the judge also wasn't buying the state's argument on the merits.
Let's talk about that then.
Okay. Right. So once our plaintiffs get their day in court, then we turn to whether this Ten Commandments monument in Arkansas is constitutional or not. And it's very clear from what the General Assembly did that it is not. So the General Assembly passed the Ten Commandments Monument Display Act for the purpose of putting up the Ten Commandments, right? And the first argument that the state makes is that's not really what they were doing. They're really trying to put up a monument that celebrates our nation's history and traditions.
Now, tell me, how does the Ten Commandments factor into our nation's history and traditions?
It truly doesn't, Rebecca. And that's sort of how things panned out when the judge got a chance to grill the state on this. There are no Ten Commandments monuments dating to the founding. As we've already talked about, the monument, so the Arkansas monument is modeled after one of these 1950s monuments that Cecil B. DeMille helped put up. But those don't have a rich history in our nation. They only date back to the 1950s. And there's no history of any Ten Commandments monuments, standalone monuments on public property before that time. Mm-hmm. So you're not talking about something that dates to the founding era. And the state, for its part, is trying to get around this fact by saying, okay, what matters is not whether a Ten Commandments monument can trace its roots to the founding, but whether our nation is religious in other ways, whether, at the founding they held Thanksgiving prayers, and whether they had chaplains during Senate sessions. And the court didn't seem to be buying that argument because it's just this sort of loosey-goosey, like we have some religiosity in our roots, shouldn't justify this modern practice of putting one religion's commandments front and center at a state capitol.
It also just seems that it's just the argument that religious people exist, therefore we can put religious monuments up on government property and that's fine. But then what does the Establishment Clause mean if that is true?
Exactly. So the state tries to get out of this in another way to say, all right, well, if you're not going to accept this sort of general religious history, then they claim we also have a history of Ten Commandments monuments that date further back. So they talk about there being a Ten Commandments monument at the U.S. Supreme Court. And the court, at oral argument, really didn't like that they tried this bait and switch tactic. Because when you actually look at their evidence, their other monuments, none of them are anything like the Ten Commandments monument at the state capitol. So the Supreme Court does have a depiction of Moses holding tablets with no words on them, but it's not like that's a standalone display. Moses is one of many figures that are of lawgivers, right? So like Hammurabi, for instance, is also there. And taken together in context, that monument is not about the Ten Commandments, it's about the concept of the law generally.
Rulemaking. Yeah.
Yeah, rulemaking.
Yeah. And we actually have information up on FFRF's website about the depictions in the United States Supreme Court. Dan Barker goes into a lot of that history and what it actually looks like there. So if people want to go on to our website, they can check that out. But let's talk a little bit about this idea, because it comes up often that the Ten Commandments is part of our government because, you know, it's laying down rules, and so is the Constitution. Like, how is the Constitution and the Ten Commandments related, if they are at all?
Yeah, our nation is founded on a godless constitution. I think, as I said in the video clip from before. But no, when you compare the Ten Commandments and what that set of commandments requires to actual American law, there's virtually zero overlap, and certainly nothing that's convincingly from the Ten Commandments in modern American law. So you start in the Ten Commandments with, I am the Lord thy God, thou shalt have no other God before me, versus the First Amendment of the U.S. Constitution, which says the government's not going to interfere with what you choose to believe in, right? Those are polar opposites.
Right.
Remember the Sabbath day and keep it holy. Well, the U.S. Constitution says nothing about that and does not require religious observance at all, right? Don't take the Lord's name in vain versus the free speech right that we have in our First Amendment. Those are polar opposites. And then you get to things like honor thy father and mother, don't covet your neighbor's wife or property, things that there are no laws about in the U.S., right? So the majority of the commandments have no place in American law at all, or are completely contradicted by American law. And then you have the few remaining ones like don't steal, don't kill, that you find in literally every set of laws across the world, including ones that have no basis in Christianity. Right. And the conclusion that you're forced to draw there is, the Ten Commandments have not uniquely affected American law in any way.
Yeah. So why do they make that argument?
They make that argument because it's sort of a stand-in for the Christian nationalist argument that the U.S. is founded on Christian principles, and that, you know, Christians are true Americans, and that non-Christians are somehow an outside group that have no place in this country.
Was there any discussion in the oral argument about like which Ten Commandments they were going to place on the grounds, and which set are actually placed there? I mean, there are many different versions, aren't there? I do not pretend to be any sort of expert in all of the like different versions of the Ten Commandments. I just know that there are different versions depending on what sect you're part of. And so what is up on the Capitol grounds, and is that of any consequence?
Yeah, so our local counsel in this case, Jerry Scholes, who was really wonderful and showed me around Little Rock while I was there, helped me find some good food to eat. Thank you, Jerry. He is fond of calling this case the 11 Commandments case because, in fact, there are 11 commandments depicted in Arkansas's monument, as there are in all the other monuments that stem from this Cecil B. DeMille history.
There are 11?
There are 11 commandments on it, and that's because when crafting these monuments, there was some concern over offending some Christian sects by putting another sect's version of the commandments, or excluding Judaism by putting a Christian version of the Ten Commandments up. And so they tried to navigate that. I mean, this is basically 10 Commandments by committee.
Yeah.
So they just divided up weird in order to try to appease everyone. And so there are 11 commandments on the monument.
Okay. And did the judge talk about that at all, or did that really?
That didn't come up.
It's just like a fun fact for us too.
Fun fact for us, the state likes to point to this Supreme Court case, Van Orden v. Perry, where the Supreme Court allowed one of these monuments to stay up in Texas, and said, "Look, our monument is exactly the same as the one in Texas," and they are, visually identical, but they were put up for very different purposes and put up in very different contexts. And what Van Orden teaches us is that context is key in these cases. Van Orden was decided on the same day as McCreary County, where the court came out the other way and said, no, this Ten Commandments display cannot stay up given the context of the displays. And so that's what the judge seemed most concerned about when talking to the state and the other parties during oral argument, was the context of these displays.
Well, it sounds like the argument went very well for our side. Did you get that feeling?
I felt good after the argument. We'll see how the judge ends up ruling. She has been very deliberate and very. She's been very good and very thoughtful in how she's approached this case. She's given all the parties lots of opportunities to brief the court, and she's not likely to come out with a quick decision. She's going to take her time and make sure she gets everything correct.
So we don't know when we would get a decision in this case?
No, but there is a trial date set,
Okay.
and typically in our cases, we brief the court on summary judgment, which is an alternative way to resolve the case without going to trial. So my hope is that the summary judgment motions are sufficient and the court resolves the case on those. But if not, we'll have a trial where presumably Jason Rapert would appear. The parties also have historians who have provided expert testimony on the history of the Ten Commandments or lack thereof. And those historians would probably be put on the stand and examined and cross-examined. So it could be a big event if it goes to trial.
Right. So it could take a while before we get any resolution in this case if it has to go to trial, and then there's probably going to be an appeal depending on the outcome of that motion for summary judgment decision or the trial.
Yes.
So, and then that would go up to the Eighth Circuit.
Yes.
Do you think there's any potential that it would go to the Supreme Court?
Well, certainly the the state's arguments are attempting to tee up an issue for the Supreme Court. Their argument on standing, where they present this novel idea that standing based on direct, unwelcome contact with an Establishment Clause violation is not sufficient to challenge that violation. That's a novel legal argument that if the Supreme Court wanted to change standing law for the worse, then it could hear that argument. But otherwise, I don't see this going to the Supreme Court. I think the Eighth Circuit will have the final word.
Okay. Okay. Well, let's see if we have any questions for you, Mr. Grover.
Sure, or for you, Rebecca. Yeah, please, grill Rebecca. She knows a lot about the law as well.
All right. So the first question is going to be a softball.
Love those.
It is, this person is fairly new to FFRF, and they would like to know if you travel around the United States often to argue cases.
They want to know how many of our members' dollars are going into, my flights. Yeah.
Yes.
No, so it's actually pretty rare that we do oral arguments. Our cases are most often decided through legal briefing, and the vast majority of the complaints that we receive, nearly 2,000 a year, most years, the vast majority of those are resolved without lawsuits at all. So we write letters to the government explaining why they're violating the law, and usually that resolves the issue. So.
Right.
Of our lawsuits, We've had a few that have had oral arguments. I've been to New Orleans a couple times, I guess last year now, to argue a couple cases there, because that's where the Fifth Circuit Court of Appeals is located, and they do Texas. And so we've had a couple cases challenging things in Texas that have gone there. But no, it's less than once a year that I get to travel for oral argument.
Okay. Well, I'm having some technical difficulties with our questions because it is asking me to verify who I am and is...
Who are you, Rebecca?
I know. So I don't think we're going to be able to do the rest of the questions, unfortunately, but it sounds like the argument really went really well, and we are expecting hopefully a good decision soon.
I guess I could talk briefly about what that good decision might mean, right? Because there are three different parties challenging this monument. The ACLU and FFRF are aligned in what we're asking for. We're asking for the removal of this monument from the Capitol grounds, and that would resolve our plaintiffs' concerns because they would no longer have to encounter it. The government would no longer be weighing in on one side, on any side of a theological discussion, right, over what you should believe and how to believe. But there's this other group, the Satanic Temple, who we have worked with on other issues in the past. We know members of the Satanic Temple, but they are bringing a different argument in this case than what we and the ACLU are bringing. They applied to have their Baphomet monument put up at the State House, and their argument is that the Ten Commandments should be taken down and replaced for an equal amount of time with their monument. And that would be the solution in their mind, because they've been denied this equal access to put their religious views front and center in the state of Arkansas. It would be certainly interesting if that ever came to pass. I don't know if the court would grant that relief, but they have a different argument that the state has spent a lot of time trying to push back against. And the judge did ask the Satanic Temple's attorney about this form of relief and what it would mean practically speaking. So.
We just had a movie event here at FFRF for our summer interns, and we watched the film Hail Satan, which talks a lot about this case because it talks about the Satanic Temple and a lot of different things that the Satanic Temple does, but they did focus a lot on this case. And this case really has been going on for a very long time. I don't remember when the Ten Commandments first went up, but we filed the lawsuit in 2018. Yep. The Supreme Court was a completely different court, and it's been taking a really long time. And I guess I just always have to bring this up. This is another example of why outside of, the uneven balance on the court, why we need court reform and a change to the federal judiciary, because a lot of these cases on the district level are just languishing for years. And there's just way too many cases and not enough judges. And so we really need to expand the lower federal bench as well as adding seats to the Supreme Court.
Yeah. The Supreme Court has done us as Establishment Clause attorneys no favors in how it interprets the clause, and also in the sort of guidance it provides for attorneys on all sides of these issues for how courts should resolve Establishment Clause challenges. So in Kennedy v. Bremerton, they did away with the Lemon test, which provided 3 prongs for how to analyze Establishment Clause cases, and they replaced it with this history and tradition test. But the court didn't apply that test in Kennedy v. Bremerton. It just talked about history and tradition in order to malign the Lemon test. And so this district court judge is really struggling with what it means to analyze the Arkansas Ten Commandments monument through the lens of history and tradition. Does that mean what's the history of Ten Commandments monuments specifically? And do we care whether that history dates all the way to the founding era, which was what was crucial in Marsh v. Chambers, which is at the heart of this history and tradition test? Or do we care only about more recent things that have happened? Is a history dating to the 1950s enough? And does it matter that that history of Ten Commandments monuments is full of mixed results, right? A lot of those monuments have been removed. There was a lot of public outcry when those monuments were placed, and FFRF has had some success getting some of those removed. Does that public outcry matter? Now, in the case of Arkansas, there was public outcry before the monument was ever placed, right? Local citizens saw from the very beginning that Jason Rapert was trying to push his personal religious beliefs onto everyone in the state by putting up this Ten Commandments monument. So they went to committee hearings and protested the monument. And then after it was put up, we filed our lawsuit immediately. So this monument has been challenged from the start.
From the start. Yeah. It's a really interesting case. I think we could talk all afternoon about it, and we have talked many other afternoons about this case. Unfortunately, I can't get the questions to come up, so we are going to have to end it here. So I guess that concludes Ask an Atheist for this week. Thanks so much for joining us, Sam.
Yeah, of course. It's been fun.
Don't miss Free Thought Radio. This week, Annie Laurie Gaylor and Dan Barker will be speaking to Michael Shermer, author of the new book, Conspiracy: Why the Rational Believe the Irrational. You can find out how to hear Free Thought Radio at ffrf.org/radio. And be sure to listen to the podcast We Dissent, which has a new episode out this afternoon. This week, we are going to talk about recent Supreme Court rulings. If you want more information about the Freedom from Religion Foundation, check out our website at ffrf.org. If you're a member already, thank you. If not, please join us. And we will see you next week on Ask an Atheist.